is about introducing you to the global project. We heard this morning the personal narratives of people of Lucy, of Gabor, and then we're now going to hear from the four women who are leading this global project. Cliona Ní Wallis at the end. Anna, you heard about, this is the Anna that Kirsten spoke about earlier, the fierce law student who converted her. Then we have Eleanor and we have Dr. Liz Brosnan as well. So Cliona, I'll hand over to you.
So first of all, I am going to give you a general introduction to the project before Anna, Eleanor and Liz bring you through the 3 working papers that they've been working on. And we hope that these working papers will be used as a starting point for respondents as we go ahead. And that we're also available now on our blog for anybody who's interested in reading them. So, as you'll see from our slides, the project is about the law in relation to, aims to change the law in relation to legal capacity for people with disabilities. And legal capacity is the right to make decisions and to have those decisions respected by the law. And it will pair people with lived experience or storytellers, as we'll be calling them throughout this project, with legal or social science scholars who are respondents. So we're thinking that respondents could be a legal academic, a legal practitioner, an activist, a social science scholar, and basically anyone with a real interest and experience in this area who thinks, yeah, that's something that I can get involved in, and that's something that we're interested in. So as I mentioned those working papers earlier, I won't go into the detail behind Article 12 and the development of the project because that's available on our website. And there's also a working paper on there on the development of Article 12 and some of the criticisms and responses to those criticisms that have been heard. So you can look at that if you're interested in it. So this new and radical approach is a focus on stories, as we've said. So we want to move away from legal research and books and to place a focus on the stories and experiences people and learn from them. There will be 8 stories and 8 responses published in a book at the end of the project. And we hope that storytellers and respondents will really work together and collaborate on this process to get the most out of the storyteller's experience, personal experience, and the respondent's professional or other experience. Before we go any further, I'll take you through the project's 4 core values. And as we're asking anyone who's interested in taking part to agree to these basic things. Now, as they outline their working papers in a few minutes, you might question some of the elements in the working papers. You might think we've missed something, that there's something you don't agree with, and we welcome this and we ask for your feedback. There's a Q&A session. But these 4 core values are something that we think anybody who wants to be involved has to agree with. So you'll see them there on the slide. They are that we believe that everyone has an equal right to enjoy legal capacity, coming from Article 12 of the CRPD. That we believe that people with disabilities should be supported in exercising their legal capacity, that we believe in respecting other people's voices and opinions, which you'll see in some grandiose we have for workshops later on, and that we believe in empowering people to drive change. The project will take place over a period of 2 years. Our first big event is today, and thank you all for coming and making it a success. Cool. But then the next important dates for you to remember are the 27th and 28th of April, which will be our first workshop, and will start that pairing process of storytellers and respondents, and that will happen in Galway. After that, we will have 4 thematic workshops. One in September this year on contractual capacity, or buying and selling things. One in November on criminal responsibility, which could be experiences with the criminal law or police. One in 2017, in early 2017 on consent, which we hope to cover consent to sex and consent to medical treatment. And another thematic workshop we have left open at the moment. So we can see what ideas you have for us in terms of themes and stories, and that might be that workshop. Or it might be consent part 2, because we realise it's a very big ask to fit both elements of consent into that February workshop. Finally, we'll have workshop number 6, a book workshop, to bring together all those elements that people have been working on for those 2 years before, we hope, a final conference and book launch with those 8 stories and 8 responses in 2018. So, what stories are we looking for? We're looking for stories about legal capacity, which, as I've said, is the ability to, the right to make decisions with legal consequences and to have those decisions respected. So you could have a story about when the law didn't allow you to make a decision. You could have a story about when the law didn't respect a decision that you made. Or you could have a very positive story about when you were supported and things went very, very well. We're looking to hear those too. Some of the ideas that we're giving you on this slide are based around our theme and the themes of the workshops. So again, contracts or buying and selling things, decisions about relationships, which we've also covered in our consent to sex workshop, decisions about medical treatment, or experiences with the criminal law or police. Or maybe you have something else that doesn't quite fit those things, but is also connected to a legal decision, and we'd encourage you to tell us about that. So the roles within the project, for those who want to get involved. You could be a storyteller, a participant, or a respondent, and I'll tell you a bit more about those in a minute. But we're also looking for artists. We are, as you see from today's program, we're interested in the power of stories to drive change, but we're also interested in how this connects with art forms, and we have a panel on this later on. And we want to incorporate some piece of art, whether it's a performance piece, an exhibition piece, something, into each of our workshops. And all we ask is that it's connected to our theme, and that it can come to us, something that's movable, if possible. And if you don't think you fit into any of those groups, you can just join our mailing list, and that's available on our blog as well. It's hopefully a very easy to use form. So for storytellers, storytellers are some people who are interested in writing for the book that we've just mentioned, who have a story around some of the topics that I've gone through, and who are happy to commit to these things. Commit to attending 3 workshops. So workshop 1, either workshop 2, 3, 4, or 5, which will depend on the story that you have to tell and which one fits your story best. And finally, that book editing workshop, workshop 6. You have to be happy to be paired with a respondent and work with them. You will have to work on your story for 2 years, and you have to be happy with us to edit that slightly, to make it maybe take a form that fits into a book and those types of things. And also happy to follow the ground rules at workshops. And we have a copy of those available here today, so you know what you're committing to before you sign up. If you don't think you can commit to all that, but you still have a story, please still try and get involved. You can attend workshops to take part in discussions. You can write a guest post for a blog. We are looking at options on how to record people so they can share their story, and we can post it on our blog in that way. We can, again, I'm talking about artists and art forms, we're looking at lots of different ways for people to share stories. Respondents are very similar to storytellers in what they have to commit to, so I'll bring you through it really quickly. Again, 3 workshops, and their thematic workshop might depend on the story that their storyteller has. We're trying to get people to attend these workshops together as they're working in pairs. They have to be happy to work with a storyteller over 2 years, and we're editing them as much as we're editing storytellers, don't worry. And again, they also have to be happy to follow the ground rules at workshops. If you want to take part, please take part. We have storytellers, our respondent application forms here today, which we can show you. They're just at the table beside the registration table. The forms are to help us pair people, to see who's interested in what stories they have, and to decide on that final open theme workshop. We want to get a sense of what stories are out there early on. Completed forms should be returned to us by the 11th of March, which is a Friday at 5 p.m. And there are options, an email address and a postal address on the form, so how to send them on. And you have to be willing to come to that and able to come to that 27th and 28th of April workshop in Galway. So please come and ask us any questions at the end, and we hope to see you all in April. I'll pass on to Anna.
I first just want to take a moment, take advantage of my time in the spotlight, to say thank you to Karina. She has done an amazing job organizing a million different things, and we're really appreciative of all the work she's done. So I just wanted to say thank you again for everything. What the 3 of us are now going to present is the working papers that we have, as Clina mentioned. The purpose of these working papers is really to sort of set a standard in a way, but also to explore specific issues around legal capacity that we think need to be explored in general for all the themes that Clina mentioned. And they're things that haven't been written about before, that we haven't written about before, and we wanted to make sure to have as a foundation and a baseline for the project. So also it's important to mention that on these working papers, a variety of us worked on them together, so none of them actually are sole authored. They were all the product of collaboration. And they're all available on the website. So the first one that I'm going to talk to you about is our paper on legal agency. Now, as I believe Gabor mentioned, legal capacity in the way it's constructed in Article 12 means two things. The right to be a holder of rights, so have standing before the law, and the right to be an agent, to act on those rights. So the question that has arisen in many different contexts is, what does that mean? What does legal agency in particular mean? When is someone exercising legal agency, and when aren't they exercising legal agency? Or even is there a moment that we aren't exercising legal agency in living in the quite complicated legal structures that we live in? We have decided that there is probably times in which we aren't exercising legal agency. But we needed to just define exactly what legal agency is in order to decide, or to at least try to decide, what Article 12 protects, and when we can say Article 12 applies. The other thing we needed to do is figure out if there's situations in which people with disabilities are exercising legal agency to a greater extent, or because of the situation they're in, the legal construct they're in, or the over-regulation of people with disabilities' lives in different areas, are they exercising legal agency in more situations than if they didn't have a disability and their life wasn't over-regulated? If you sort of get my meaning. And so we wanted to look at that as well, and the areas in which we identified that that could potentially be a problem is in institutional settings, or in settings where the person is in a relationship of domination, where there's someone controlling an individual's life. And I'll talk more about that in a moment. The last reason that we wanted to do this definition of legal agency is to deal with the concern that Article 12 applies and that your right to make a decision is protected in all areas, in every moment of anyone's life, which then would mean potentially quite a burdensome right to due process for even very small decisions. We came across this problem particularly in dealing with law and policymakers who were concerned that if they changed the law to be Article 12 compliant, they would be somehow allowing people with disabilities a right to make decisions that is greater than people without disabilities. Of course, this was never the intention of the Convention on the Rights of Persons with Disabilities. In fact, the entire convention only re-describes rights that already exist for everyone. And we thought another way to explain this, particularly to law and policymakers, is to show them exactly when an exercise of legal agency is occurring and what Article 12 protects. So, in our endeavor to come up with this definition of legal agency, we thought, surely someone else has done this before. Surely there's many, many great people, and let's be honest, they're usually men, if you go back in history in terms of how the law was constructed, who have come up with a definition of legal agency. We searched high and we searched low, and we did not find one. There's many definitions and many court rulings around when a court, in particular, or when the law is not willing to recognize someone as a legal agent, often directly tied to a disability. But in fact, we could find almost nothing on when an individual is exercising legal agency, or what an exercise of legal agency specifically is. So we decided that based on our knowledge of relevant case law and scholarship in the area, we would put those different factors together that we know about and come up with a definition. And this is the definition that we have come up with. Legal agency is an action or inaction that the individual intended and which has legal consequences or creates, modifies, or extinguishes a legal relationship. So, as you can imagine, you can spend an entire day probably applying this definition to different circumstances and figuring out whether you're exercising legal agency or not. I won't do that here, but we wanted to present you with this definition to give you the opportunity to take it away and do that. And as I mentioned, this is all available on your website. So just to highlight briefly, what we decided is not essential in a definition of legal agency is a requirement of understanding. And this is because we can be exercising legal agency in any given moment. Our actions can have consequences that have legal effects, whether we understand them or not, and especially whether we understand the particularities of what those legal consequences could be. I mean, I think many people are familiar with the concept of ignorance not being a defense. So, before the law. So you can very much be exercising legal agency without an understanding of exactly the fact that you're even exercising legal agency. In fact, I believe we do that every day. And without an understanding of exactly what the legal consequences would be. We did decide that there needs to be an element of intention. And again, this is based on many different areas of the law and legal scholarship that we've looked at. In general, there has to be some even base level of intention to take an action in order to then be responsible for that and have that action ascribed to you. Again, there's more about this in the paper, and I won't get into it in too much detail today. I think probably the most important thing about this paper actually is when we took it and applied it to lived experience of disability, and experiences that many of us face personally or in our lives of people that we know. And those are when a person with a disability faces a decision-making barrier. And what happens when you're faced with a decision-making barrier and you have to exert a different kind of power and a different kind of energy than if that barrier didn't exist. So, as we talked about earlier this morning, decision-making barriers are faced by people with disabilities in institutional settings, but they're also faced in group homes, in family settings where you might be in an oppressive environment with your family, from service providers, or maybe even just confronting it with the law itself, so in a criminal setting or other settings. We thought this was really important to figure out what this means, and what this means for whether the individual is exercising legal agency when faced with a decision-making barrier, and then if Article 12 then protects that decision. We used Republican theories of domination as a theoretical framework. To be quite frank, we used that in order to make our work accessible for legal scholars. That's why we did that. We knew that we needed a very old, or relatively old, legal theory in order to give legitimacy in the eyes of legal scholars to what we're doing. And we used that and applied that to the context of disability. And what we found, basically, is that in many experiences that we've heard of from people with disabilities and that we know of in our own lives, they are experiencing domination. Sometimes coming from dependence, and sometimes coming from other places. The important part about this is that what our conclusion is that in these relationships of dominance, and when people with disabilities are experiencing this type of decision-making barrier, but we can actually also fairly say this when anyone is experiencing a decision-making barrier, you're forced to exert legal agency in situations in which you wouldn't if the decision-making barrier wasn't there. And therefore, Article 12 protects that decision. So just for a brief example, if you're living in an institutional setting where your daily schedule is completely prescribed by the staff or the head of the institution, that's a decision-making barrier for you, and could potentially be a relationship of domination as well. So in that decision-making barrier, in order for you to decide, in order for you to have the power to change that schedule, you may have to take some kind of action that would be an action, again going back to what our definition is, that is an intentional action and has actual legal consequences. Also because you're often in a contractual relationship, or someone is in a contractual relationship with that institutional setting, or could potentially be a service provider as well. Now, the interesting thing and the important thing as well is that, that decision to change a daily schedule probably wouldn't be an exercise of legal agency if you weren't living in an institution or living in that relationship of domination. And therefore what our finding is that people with disabilities are often forced to exercise legal agency to a greater extent than people without disabilities because of these decision-making barriers. And therefore, Article 12 would protect a wider range of decisions for people with disabilities, potentially, and it's very important, as we can see from the talk earlier today, and as we will see from the rest of the talks later on today. So I'm going to pass over to Eleanor now to talk about the next working paper that we did dealing with a slightly different issue.
Sorry, we're just going to shuffle seats here so I can see what's going on.
Could I just ask, sorry,
we're going to have a Q&A at the end.
Good.
Yeah. So the next paper we wrote is about state intervention. And we really wrote this because people keep asking the question, okay, if people have the right to make all of their own decisions, at some point in any of our lives, we might want people to intervene in our life when we're in danger, when we're doing something that's against the law. We would expect maybe the police to intervene. So what are the times when the state, or people acting on behalf of the state, can intervene in the lives of everybody, including people with disabilities? So we really wanted to answer that question in a way that was more in keeping with human rights than most of the other answers to that we've heard so far. So our questions were, when does Article 12 allow for the state to intervene? We were only looking at when the state intervenes in the private lives of adults. And to be honest, we're not even looking really at the criminal law here. We're looking at when, outside of the criminal law, can the state intervene in the person's life if they're an adult and it's part of their private life. And then what kind of intervening could we do there that would actually respect all of the person's human rights? Because a lot of the time when people intervene in someone's life, they say they're intervening to protect the person, like Gabor talked about. But they're actually harming the person more than protecting the person. And they're protecting maybe one of their rights, like the right to health or the right to stay safe, but they're not protecting their right to make choices, they're not protecting their dignity, and they're not protecting their right to give informed consent.
So we wanted to look at the totality of the person's human rights. So first of all, we started off by looking at the way in which the law intervenes right now in people's lives outside of the criminal law, and mostly outside of, let's say, mental health laws as well, which also are a clear intervention, a coercive, forced intervention in people's lives. So we mostly looked at things called adult protection orders or adult safeguarding orders. And we found that these are usually tools that the state has in various countries around the world that allow the state, maybe social services, to intervene in a person's life because they believe that person to be vulnerable and at risk. That person might be experiencing abuse, they might be in a crisis, and the state thinks that that's the appropriate moment to come into that person's life and to try to support them, although, as you've heard from other speakers, typically the state has not done a good job there. But when we looked at these adult protection orders, or adult safeguarding orders in more detail, we found that the definition of who is a vulnerable adult that the state can intervene on is usually discriminatory based on disability. So we can't intervene on anyone's life because we think they might be having a tough time. We can only intervene when they have some label or diagnosis, and that's why we intervene. Even if that law itself doesn't include that label or diagnosis, in reality, it's always people with disabilities or people with labels and diagnoses of disability that have the law intervene in their life in this way. The other problem we have with the existing law is that it actually gives quite a lot of power to intervene at a very early stage when we're not actually sure what harm the person might be facing. And as we said, the harm that's done by the intervention is often worse than the harm the person was thought to be facing. Sometimes the state intervenes in the lives of people because they're being abused by other people. But instead of punishing the person who's doing that abuse, they actually intervene in the life of the person who's being abused. And we think that that's not an appropriate response. We think that if someone is violent towards another person, is abusing them, is exploiting them, that person should be punished by the law, not the person experiencing that violence or that abuse. We also looked at what powers we have in the law already if we got rid of all of this adult safeguarding and adult protection to intervene in people's lives. So one example that I know Chris has talked about before is when people are hoarding a lot of things in their apartment and it starts to become a public health issue. So, maybe rats start to come and the neighbours start to complain. There are powers to intervene in situations like that anyway, which aren't related to disability, although, again, you might say that a lot of the time they get applied when the person has some label of disability. And there's always the criminal law. So sometimes people say, oh, we're intervening in this person's life to give them treatment or to keep them safe, because if we didn't, they might end up breaking the law and then they would go to prison and that would be worse. But again, we think that sometimes if you're getting your right to equal legal recognition, that also means that you have equal legal responsibilities and you have to be prepared to be accountable to the law. So we looked for other examples of what we thought was a better way for the state to intervene in people's lives. And one of the things that we thought was a good example was that in response to people who have been victims of or survivors of human trafficking, there are certain measures that the state can do outside of the criminal law to punish the traffickers, but actually to support the people who have experienced that situation. But the good examples that we looked at meant that the state could only intervene to give support to survivors of human trafficking with the person's consent. And a lot of the time when we look at the interventions that the state does to people with disabilities, they're not doing it with the person's consent. So one new idea that has emerged in recent years since Article 12 came out is one developed by Michael Bach and Lana Kersner, who Chris mentioned earlier. And they have this idea about when we should maybe stop people making decisions for themselves or when we should intervene in their lives to protect the person. And they use this definition of the person experiencing serious adverse effects. Okay? And I've just put the quote on the slide of how they define that. So they talk about the person being at risk of experiencing a loss of a lot of their property, or being unable to provide the basic necessities of life they need themselves or for their dependents, so let's say their family, their children. They talk about we should intervene if the person is at risk of experiencing serious illness or injury and being deprived of their liberty or personal security. Where the person has threatened or is attempting to cause physical and or psychological harm to himself or has behaved or is behaving violently towards another person and has caused another person to fear physical and or psychological harm. So they say that if the person is doing one of these things, and if we think that the person is not able to what they call act legally independently, which is basically means that the person doesn't understand the consequences of their actions, they can't weigh up decisions about what they're choosing to do, that's a ground for the state to intervene in their life. So we looked at that in this project and we think that's a bit still not quite what we're looking for, because I still think that there are times you would be allowed to intervene under that I would not accept, that I would think would be violating my human rights. I was particularly nervous about the idea that if you're going to lose some of your property, that gives the state the right to intervene to stop you. Because we all know that people make decisions about spending their money in ways that other people might think are not a good idea, but that's their choice and that's their responsibility. So what we came up with instead is a different idea. We talk about the state intervening in the lives of everyone, including people with disabilities and people without disabilities, when the person is at imminent and grave harm to their life, health, or safety. So not their property, not other people, to the person's own life, health, or safety. Because we think if the person is harming other people, that's what the criminal law is for, and that's what we should look at there. So there's a power to intervene, we think, for the state, based on these ideas about imminent, so the harm is happening right now, and grave, it's very serious harm to the person's life, health, or safety. But that's not enough, because again, what I think is serious harm to your life, health, and safety is not what another person might think is like serious harm or grave harm. So we added another step, which is the proportionality test. So in order to intervene, you must decide how you're going to do that, and you must do it in a way that's proportionate to the risk of harm that the person is facing. So here's a pretty standard definition of proportionality, and I have my own skepticism, I have to say, about proportionality tests and whether they work. But for now, this was the best we could come up with in thinking about when it's right and just to intervene in people's lives. So it's a proportionate intervention if it is pursuing the legitimate aim of de-escalating the situation of risk to harm to life, health, and safety of the person. But it must be a good response to that. And we have now learned, mostly from the lived experiences of people with disabilities, about all sorts of sensitive, humane responses to people experiencing distress that are much more effective and much more protective of that person's human rights than what the state has been doing with coercion. So the examples we use in the paper, which you can read more about, include ideas about family group conferencing, open dialogue, and circles of support. Now, there will always be hard cases about when we should intervene in the person's life, and one of those hard cases is around end-of-life decision-making. But we have made the decision within these papers, our position is that we don't believe that forced medication and force feeding, where the person has clearly expressed that this is not something they want, would ever be a proportionate, humane, human rights protective response to a person experiencing a risk to their life, health, or safety. Final thing I want to say is about powers of entry. So we had a long discussion in the project while we were writing these papers about what do you do before this point, before it's reached this crisis and the person is now at risk to their life, health, or safety. Obviously you do all of the support, you provide the person, you're doing everything much earlier in the process so it doesn't reach this crisis. But there might also be a time when we can't access the person to figure out what's going on with them because there's other people blocking us from checking in with that person and seeing what's going on with them. So if, let's say, that person is being kept captive in their house by a family member, for example. And anytime someone who wants to support that person comes to visit them, the family member says, they don't want to see you, they're fine, you know, I don't want to let you in. We also think that there should be a power of entry in situations like that. Before we know whether there really is imminent and grave harm to the person's life, health or safety, just to check in with the person because we believe them to be in need of support and assistance, and we think there's a risk that they might be experiencing abuse, neglect or coercion. But if you do get access to the person using that power and then they say, I'm okay, we have to trust and respect the person's choice to live in that environment and continue to offer support and reach out to that person so that if they choose, they can leave that environment. So I'm going to end it there, and I'm going to hand over to Liz, who's going to talk about the last paper on consent, and we'll take questions at the end.
Hi, so our paper, sorry, I need my glasses to see the screen. Our paper was looking at consent, and consent especially in the area of consent to sex and consent to medical treatment. So the question we were trying to answer is, how do we know when somebody is giving free and informed consent, which is necessary to make an action, to make something legally binding? So, free and informed consent being necessary to make an action legally binding. How can we be sure that somebody's doing that without getting involved in functional assessment of the person's mental capacity? Because again, we're really working from the idea that legal capacity is the standard that we is universal. So functional assessment gets into questions of somebody whether they understand the consequences, and again, that's usually discriminatorily applied to people with disabilities. So that's the starting question. We looked at consent around consent to sex and marrying that idea with consent to medical treatment. So there's a lot of scholarship, legal scholarship around consent to sex and how do we know it exists, and especially so we were looking to see whether that scholarship will carry over and to exploring what is consent to medical treatment as well. So we applied a freedom to negotiate standard based on somebody's will and preferences, again, to getting away from the idea of understanding, asking, is there agreement? So one of the things that we need to determine whether there is agreement and enough sufficient communication to determine whether the person's consent is present or absent. And part of the idea in our paper is to really respect the idea of refusing. Again, how do we know and how do we deal with the idea when somebody refuses consent? So again, it's making sure that we have enough support offered to people, and to make sure again we understand what it is that somebody intends and wants to do, what is their choices, and to find ways to suggest solutions to when people have conflicting will and preferences. For instance, somebody again who refuses medical treatment because say somebody with anorexia who doesn't want to eat and doesn't want to die. So in that case, how do we offer the support to somebody to be sure that we're respecting their right to refuse treatment? So so we looked at the current position in law. So currently there are legal tests that determine whether consent is present, and they differ across lots of different areas in law. So there are different standards for whether people are able to consent to marriage, to property, health treatment and sex. But the two that we particularly looked at in this paper are around marrying the idea of consent to sex with consent to and consent to medical treatment. Particularly when you look at laws around a woman's right to consent, or anybody's right to consent to sex, but quite often in this area, it's often based on assumptions that woman is this work arises in cases where people are trying to determine whether to prosecute somebody for rape, and so in those laws there's a patriarchal assumption that woman is always available for sex, and so the questions as to whether yes or no arguments are definitions enough to respect the right for a woman to have bodily autonomy and not to be forced into sex with somebody that they don't want to have sex with. Those judgments are often based on the assumption, that women don't have the same rights over their bodies as men do, or the women are available for men's to men's sexual desire. Okay, thanks. Yeah, pleasure. So you can see it's a really complicated area, but essentially the coming from a feminist perspective, everybody needs to. So we begin to unpack the patriarchal assumptions that are there around ideas about consent and what it means to have bodily autonomy. And quite often mental capacity is used as a precondition for valid consent. And we would reject that and say that we need to start from the presumption that everybody has the right to determine their own, what happens to their own body, and so that we would be saying that mental capacity is not a good standard. So that, in other words, whether somebody is said to understand the consequences of the decision or not is not enough to determine whether or not consent exists. So that's the current position that we're challenging. And we propose that for our definition of consent, we first of all need to recognise everybody's legal capacity, right to be recognised as persons in their own right. Then we move to the understanding what it is what is the communication that's going on between people. And so it's not simply enough to say that in defence of rape that yes, somebody was simply a yes or no question is not enough to know whether. So it's not enough to just say, well, yes, the person indicated that they were willing to be to proceed with sex or to enter into to consent to medical treatment. But in fact, we need to build in a standard that respects the freedom to negotiate. That people need to have a discussion between the potential sexual partners, or in terms of the person and their engagement with doctors. It is really important that there's space to determine what it is that the person wants, so that we're definitely not allowing the standard of best interests in medical treatment to be an essential element. We must also, we looked at some conditions that must be met, or that must be minimised in order to ensure that consent is valid. And those conditions would include situations where people are being coerced, and that's particularly evident in a lot of the writing about mental health environments where the freedom the ability to truly consent to sex is compromised by the coercive situation that people are in. Another condition that is often present is the undue influence that people are under, whether it's a question of family members or people say in institutions who are dependent on other people for their care, definitely would fall under undue influence, because it would be quite difficult to refuse to have valid consent when somebody doesn't have the right to, or are dependent on other people because of their conditions and their living conditions. And again, that would be similar to Anna's idea of domination. And the final point is that the vast power imbalances that exist between, say, many times men and women, like a woman who might be dependent on her husband or her partner for financial support and support for the children and access to the house. And in many cases, women would be giving consent, not giving consent, but kind of agreeing to go along with sex for the sake of in other words, complying with unwanted sex because they're in a position where the power imbalance is too great. So these are conditions that must be eliminated or minimised in order to ensure that consent is genuinely valid and respectful of the autonomy and the legal capacity of people. So just to conclude, and we've laid this out in the paper, and I hope I've kind of conveyed some of the ideas adequately, but what we're saying is in order to have valid consent, and to understand what it is, we need to apply the idea that people have the right to freedom to negotiate, to have a proper free discussion, negotiation between the partner on the level of consent to sex, or between the treating professionals and the individual. So that it's not enough to get a simple yes or no from somebody, but there must be space for freedom to negotiate the consequences, the discussions, to have proper and adequate, say in medical context, to understand that, to have proper discussions about the consequences of the implications of the decision of the treatment. And that is a highly complex area, as medical science is so advanced that in many cases we don't have full understanding. And so it's enough we would say that we need to apply a standard about whether somebody's will and preference is being respected, and not just assuming that to work on somebody's best interest. We would be clear that when there is coercion or undue influence, that it is really difficult to say that there's proper valid consent is being offered to somebody. And so finally, we would also say that it's important to reduce the power imbalances in order to try and assume that there's sort of valid consent being offered between the two parties. And in all of our work, we have done our best to question whether the idea of consent is linked to functional tests and mental capacity. Because if you have if we move away from the idea that people understand the consequences of their decision, well, we need to be quite clear that most of us don't understand the full implications of our decisions, and to apply discriminatory tests of mental capacity on people with disabilities is a particular challenge in the area of determining what is valid consent and to be compliant with Article 12 of the Convention. So I would think that it's a complex area, and we've spelled it out in the paper, which is quite long, but I do hope people feel that if it's an area that you're interested in, that you will take time to read the paper and offer feedback on the ideas that we're proposing. because it is quite a challenge in a different area to be looking at some of these areas in relation to moving away from a discriminatory application of legal capacity and mental capacity to people with disabilities. So I think to leave it at that because we have time for questions.